I'm Angie Gerding, State Program Director with Advocacy and Protective Services.
And I'm Derek Graham, an attorney with the law firm of Resch, Phillips & Graham.
These are 5 things you need to know about guardianship.
Guardianship should always be a last resort. When deciding whether or not guardianship is appropriate, it should not be based on a certain diagnosis or condition, but rather it should be based on a set of facts and circumstances that tell you whether or not someone needs a guardian. To be eligible for guardianship, someone has to meet the legal definition of being incompetent, but before getting to that point, you have to explore whether less restrictive alternatives like powers of attorney, supported decision-making, representative payees, or other types of alternatives are available that make guardianship unnecessary.
Different types of guardianship can be established depending on the need of the individual. Guardian of the person gives the guardian the authority to make day-to-day decisions on behalf of the person. These decisions often include determining where a person will live, the type of medical care they receive, and who will provide services to them.
Number 3, know the role of the court. The court is what's referred to as the superior guardian, meaning they have the final say on all facets of a guardianship. Once a guardianship is established, if ever there's a dispute or a concern about the performance of a guardian or for just general oversight of the guardianship, the probate court will remain involved. Don't be alarmed because the probate court is not there to micromanage the guardians. They are counting very much on the guardians to make good decisions in the day-to-day life of the individual. A guardian does have to keep the court informed about certain information, and they do that by filing annual reports or letting the court know anytime there's a change of address or other significant event in the life of the individual.
Just because a person has a guardian, it doesn't mean they don't have any rights. Certain individual rights remain in place even after a guardianship has been established. Some of these rights include the right to participate in decisions about your life, the right to have relationships and personal privacy, the right to vote, and the right to drive. It's important to know that many safeguards exist to help ensure these rights are protected. For example, providers in the DD system are required to follow the DD Bill of Rights, and concerns about guardians can be reported to the probate court for review.
Guardianship does not have to last forever. While it's true that some individuals will need a guardian their entire life, for other individuals, guardianship may have just been established early in their life because they had not yet reached the maturity level necessary to manage their own decisions. Some people reach that maturity level later in life and they no longer need a guardian. As a guardian, if the guardian finds themselves doing very little work on behalf of the individual, that's a great sign that guardianship is no longer necessary. A guardian or a person under guardianship should never be afraid to go back to the probate court and say, I believe this guardianship is no longer necessary. For more information, please visit www.ddc.ohio.gov and search for guardianship and estate planning.